Hello dear students, I am Dr. Prinpreet and today I am back again one more time to talk to you about yet another topic from the paper of Law and Economics Part 1. The title of the topic is Economic Theory of Settlement Bargaining. Now at the very introduction, a thorough framework that aims to explain the dynamics, the tactics and the results of settlement talks mainly in relation to legal disputes is what is known as the economic theory of settlement bargaining. This theory, which has its roots in game theory, the decision theory and the microeconomic concepts, explains why parties resolve conflicts out of court as well as the variables that affect settlement choices and the circumstances that lead to settlements. The process by which opposing parties work out a settlement without going to a formal trial or court judgment is known as settlement negotiation. Numerous legal, psychological and economic variables may have an impact on the choice to settle. Examining the incentives, expenses, the dangers and the tactics that influence parties to settle or not settle is necessary to comprehend the economic theory underlying settlement negotiations. Settlement bargaining is an essential feature of the legal system that enables the parties to settle disagreements through a discussion as an alternative to formal litigation. Economics may be used to better understand this process by shedding light on the incentives, the tactics and the results that lead the parties to resolve their differences out of court. Based on the ideas from game theory, the decision theory and microeconomics like I just mentioned, the economic theory of settlement bargaining aims to clarify why parties frequently choose settlements over litigation, how they weigh their options and the circumstances in which the settlements are most likely to occur. Fundamentally, settlement negotiations are cost-benefit analysis in which parties compare the possible advantages of going to the trial against the costs and dangers of going to the court. In order to avoid the costs, the delays and the uncertainty associated with trials, many parties choose settlement. Numerous elements such as the case of financial and legal ramifications, the parties' respective bargaining positions and the legal context of the disagreement all have an impact on the decision-making process. The economic theory of settlement bargaining is particularly significant because it offers a framework for comprehending the settlement's wider ramifications for the society and the judicial system, in addition to helping to explain why settlements will happen at all. Settlements, for example, can save costs, ease the load on the courts and produce more predictable results. But they can also give rise to questions of justice, particularly where disparities in power or information are present between the negotiating parties. The theory of settlement bargaining provides a strong foundation for comprehending why parties settle, how settlements are negotiated, and what these agreements mean for the larger legal system by using the economic ideas. Additionally, it offers perspectives on possible policy changes that would promote more equitable and speedy settlements, which would eventually strengthen the judicial system's effectiveness and equity. Now, let us examine a few fundamental ideas which are necessary to comprehend the economic theory of settlement negotiations. These ideas include risk aversion and expected utility. Because parties are risk averse and would rather have a certain conclusion than the unpredictable outcome of a trial, they would frequently settle. The theory examines how parties weigh the potential benefits of reaching a settlement as opposed to proceeding to trial taking into account the likelihood of various outcomes and their associated costs. Second here is the transaction cost. The high expenses associated with litigation may be a major influence on the party's decision to settle. The economic theory looks at how the court expenses, attorney fees and the length of the litigation affect the choices to settle. Third point here is asymmetric information. Such a situation occurs when one side has access to more or superior knowledge than the other, which might cause them to behave strategically during their talks. The idea explores how parties may attempt to regulate or lessen these imbalances, as well as how information discrepancies can impact the settlement results. Fourth point, bargaining power and strategic interaction. During the settlement talks, the parties' relative bargaining power and strategic interactions are very important. The models from the game theory can be used to explain how the transaction parties bargain, they make proposals and they react to one another's actions when settling a dispute. Fifth, the legal and economic environment. Settlement negotiations are also influenced by the larger legal and economic environment, which includes market dynamics, judicial decisions and past legal precedents. The idea looks at how these outside variables affect the motivations and the tactics of the bargaining parties. Now we move on to discuss the significance of settlement bargaining. For a number of reasons, settlement negotiations are an essential component of every judicial system. First point that highlights this significance is cost effectiveness. Trials may be costly, time and resource consuming, and the disputes are frequently resolved more quickly and cheaply through settlements. Second point that highlights the importance is risk management. The jury's verdicts, the court's interpretation and the strength of the case all influence how trials turn out. Through settlements, the parties can escape the unpredictability of the trial results. It can also control the outcomes. When parties settle, they maintain authority over the parameters of the agreement instead of letting a judge or a jury make the final decision. It can help in preservation of ties also. Settlements can help keep company or personal ties intact that could otherwise be harmed by a public court battle because they are less combative than trials. Now, what is the theoretical basis of settlement negotiations? Numerous fundamental ideas from game theory and economics serve as the foundation for the economic theory of settlement negotiation. These ideas aid in the explanation of how parties approach settlement talks, assess possible outcomes and choose the possible tactics. First point here is game theory and strategic management. A framework which is known as the game theory can be used to analyze situations in which parties make decisions that are interdependent, meaning that each party's result will be dependent upon both their own and the other party's actions. Prisoner's dilemma concept is also used in this context. The classic game theory model, which is known as the prisoner's dilemma, shows how two parties may decide to cooperate or settle or defect, or that means to litigate. Mistrust and strategic motives might cause the parties to defect, leading to a trial, even if mutual collaboration or settlement is frequently the best result known for both of them. In case of using Nash equilibrium, when both the parties decide on strategies that are best given the other party's strategy, a Nash equilibrium in the context of settlement negotiation takes place. When things are in balance, neither side is motivated to alter their approach on their own, which could result in the settlement. There are models of bargaining theory as well which can apply here. Many game theoretic models focus on bargaining in particular, and one such model is the Rubinstein bargaining model, which takes into account how the settlement process is impacted by the timing of the offers and counter offers. What is the expected utility theory? A key idea in decision theory that explains how reasonable people make decisions in the face of uncertainty is expected utility theory. Parties assess the expected usefulness of reaching a settlement rather than going to the trial during the settlement negotiations, taking into consideration their risk tolerances, prospective outcomes and probability. For risk aversion, many people are risk averse, which means they would rather not take a chance on something that could have a bigger payout but a higher risk. Parties are frequently motivated to settle because it offers a guaranteed outcome and allays their fear of risk. In case of expected value of litigation, the likelihood of victory, the potential amount of damages that are awarded, and the expense of litigation, they're all taken into account by the parties when determining the expected value of proceeding to trial. Reasonable parties will probably settle if the value of a settlement offer exceeds the projected value of litigation. Evaluation of settlement offer. The parties weigh the settlement offer against the anticipated value of the trial, how each party perceives their odds of going to the trial, and whether the settlement offer represents a better predicted outcome are important factors in settlement negotiations. The costs of transactions and litigation. The transaction costs of litigation have a big impact on settlement negotiations. These expenses consist of the time spent on the lawsuit, the court costs, the legal fee, and the opportunity cost of pursuing litigation instead of other worthwhile endeavors. Now, talking about the cost benefit analysis here, in order to decide if settling is preferable to pursuing litigation further, the parties perform a cost benefit analysis. Settlement is frequently encouraged by high litigation expenses even when parties think they have a solid case. Fee shifting and legal expenses. In certain legal systems, the losing party would have to reimburse the victorious side's legal costs, and when the parties consider the possibility of paying the expenses further, the possibility of fee shifting may have an impact on their decision for settlement. Time value of money. This is another important factor to take into account, because the longer a lawsuit goes on, the less money is available for an eventual reward. For this reason, settlements which might result in quick payment are frequently chosen. Uncertainty and asymmetric information. Information asymmetry, or the situation when one party knows more or better information about the case than the other, is one of the main obstacles in the settlement negotiations. The disparity may result in erroneous strategic decisions, impediments to settlement, and strategic behavior. Asymmetric knowledge. In settlement talks, one side may take advantage of the knowledge that gives them an advantage over the other on the strength of their case, the chance of winning, or the possible damages. A disadvantage for the party with less knowledge could result in fewer than ideal settlements. Signaling and screening. To control information asymmetry, parties may use the method of screening or signaling. A party may, for instance, employ discovery procedures to gauge the other party's desire to settle, or they may make a low settlement offer to convey their belief in a strong case. For ambiguity and uncertainty, settlement talks may become more difficult due to the inherent uncertainty of trial results, even in situations when both parties have access to comparable material. The decision-making process is further complicated by uncertainty regarding the potential interpretations of the law or facts by a judge or a jury. Now, I'll discuss the factors that affect settlement decisions. The nature of the disputes, the traits of the parties, and the larger legal and economic landscape all play a role in determining whether to settle or go to the trial. First aspect here is features of the dispute. When it comes to settlement negotiations, the nature of the dispute itself is extremely important. Depending upon the issues that are involved, the available remedies and the complexity of the case, some disagreement types are always easier to resolve than the others. For complexity and ambiguity, because it is difficult to predict trial results in complicated cases with high degree of ambiguity like patent disputes or sophisticated commercial litigation, settlements are more likely to occur. Now, the third factor here can be the monetary versus the non-monetary remedies. Since the parties can agree on a precise sum, disputes involving only monetary claims are frequently easier to resolve. Settlement negotiations may be more difficult in situations where non-monetary remedies, including injunctions or specified performance, are involved. One more factor here is the emotional and the reputational factor. Defamation and personal injury claims, for example, may be more acrimonious and less likely to settle than other types of disputes with high emotional or reputational interests. Parties may go to trial in order to establish a legal precedent or to seek public vindication. Now, what are the characteristics of the parties? The likelihood and conditions of a settlement are also heavily influenced by the parties to the dispute. Settlement talks may be influenced by variables like the parties' respective tolerance of risk, their financial resources, and their bargaining position. Negotiating power. In settlement negotiations, the parties' respective negotiating strengths are also very important. A party with superior financial means, legal know-how, or market clout could be able to bargain for better settlement conditions. Then there can be some importance played by risk preferences also. Various risk preferences may lead to various approaches to settlement talks amongst the involved parties. Risk-tolerant parties might be more inclined to take a chance on the verdict of a trial, whereas risk-averse parties are more likely to settle to avoid the uncertainty of a trial. Reputation and legal strategy. Certain parties might be more interested in establishing a precedent in the law or in protecting their reputation. These parties may be less likely to agree to a settlement and instead favor a trial in order to create a public record or shape future legal decisions. Then, discussing about judicial and legal environmental factors. Settlement negotiations may also be impacted by the larger legal environment, which includes the conduct of judges, the effectiveness of the courts, and the accepted legal norms. I'll discuss judicial efficiency here. Settlement choices may be impacted by the backlog and effectiveness of the courts. Parties may settle more frequently in order to avoid drawn-out legal disputes in places where trial delays are caused by court congestion. Now, what is the behavior of the judiciary here? By expressing their opinions about the merits of the case or by holding pre-trial discussions or mediations, the judges can promote settlement. Settlements may also be aided by judicial pressure or direction, particularly when the judge feels that a trial is absolutely not required. Legal standards and precedents. Settlement negotiations are also impacted by the predictability and clarity of the legal precedents. parties may have a better idea of their prospects of winning at a trial in areas of law where there are established precedents which could result in more settlements. On the other hand, parties might be more inclined to file a lawsuit to make the law clear in areas where the standards of the law are changing or unclear. Economic and market conditions. Settlement negotiations can be significantly impacted by market and economic conditions, especially in cases involving large financial stakes or commercial disputes. Economic downturns. In order to maintain cash flow and avoid the high expenses involved in litigation, firms may be more likely to settle disputes during these times. In contrast, parties may be more inclined to file a lawsuit in a growing economy because they believe the potential profits in that case will be greater. Market competition. Businesses may resolve disagreements to avoid going to the court in order to protect their brand or competitive position in an extremely competitive market. Settlements may be motivated by a desire to keep up the commercial ties or steer clear of bad headlines. Insurance and indemnity. Agreements pertaining to insurance or indemnity may also have an impact on the choices for settlement. Now, what are the models used in settlement bargaining? A number of economic models have been created to describe how settlement negotiations work. These models forecast the possibility and the conditions of settlement by taking into account a number of variables, including information asymmetry, transaction costs, and strategic behavior. I'll first discuss the model of asymmetric information. The asymmetric information model is a key economic theory in settlement bargaining, predicting the likelihood and terms of settlement based on factors like asymmetry of information, the transaction cost, and the strategic behavior. It assumes that one party has private information about the strength of their case, while the other party relies on incomplete information. This model predicts that information asymmetry can lead to inefficient settlements or prevent settlement altogether. It is a particularly relevant case in complex financial disputes, intellectual property, or situations where only one party has specialized knowledge or expertise. Moving on to the model of strategic bargaining. The strategic bargaining model is a negotiation strategy that focuses on the tactics used by parties during settlement negotiations. It incorporates the elements of game theory such as signaling, commitment, and bargaining power. The model examines how parties make initial offers, respond with counter-offers, and adjust their strategies based on the other party's response. It also highlights the use of commitment strategies to strengthen their bargaining position and the strategic delay of negotiations to gain more information or wait for favorable conditions. Then we have the model of litigation costs also. The litigation cost model highlights the influence of transaction costs such as legal fee and the court expenses on settlement decisions. It suggests that parties weigh the benefits of trial against litigation costs with high costs leading to settlements. The model also considers fee shifting, where the losing party pays the winner the legal fee, which can influence the settlement bargaining. The time value of money, which diminishes as the case progresses, also influences the decision for settlement. Settlements which offer immediate payment are often preferred over longer term litigation. There is one more model here which is called the model of risk aversion. The risk aversion model is a theory that explains how the attitudes of the parties towards the risk influence their settlement decisions. It assumes that parties have different risk preferences, with some being more risk averse and others being more risk tolerant. Risk averse parties settle to avoid trial uncertainty, while the risk tolerant parties may hold out for higher trial rewards. The model helps to explain why some parties are always more willing to settle even in strong legal positions, and emphasizes the importance of understanding the other party's risk tolerance in negotiation strategies. This model can also be applied to various settlement situations. Now, we discuss the policy implications of settlement bargaining. The legal system of any country is likely to be significantly impacted by the economic theory of settlement negotiation, especially in terms of how laws and processes might be created to encourage conflict resolution. First point here is encouraging efficient settlements. Legal policy should aim to promote efficient settlements that resolve disputes fairly and at the lowest possible cost for the parties and the court system. This can be achieved through reducing the cost of litigation through fee shifting rules, legal aid and streamlined procedures. Promoting alternative dispute resolution methods like mediation and arbitration can also increase settlement rates and provide parties with more options for dispute resolution outside the court. Policies that promote transparency and access to information can also reduce information asymmetry in settlement negotiations, leading to more informed and fair outcomes. Second, addressing power imbalances. Power imbalances can lead to unfair settlements, especially when one party has more resources or greater legal expertise. Ensuring that both parties have access to competent legal representation is very crucial for fair settlement bargaining, and legal aid programs and pro bono services can help to level the playing field. Regulating contingency fee can prevent attorneys from exploiting vulnerable clients and ensure settlements are in the best interest of the parties. Third, protecting the integrity of the legal system. Settlement bargaining should not undermine the legal system or public confidence in the courts. Transparency and accountability are crucial in the settlement process, ensuring fair outcomes and consistency with the legal principles. Policies requiring judicial approval can provide an oversight, but settlements do not create legal precedents, so resolving important legal issues through trials and published opinions is essential for the development of law. Now let us conclude. The economic theory of settlement bargaining is a framework that explains the dynamics, the tactics and the results of settlement talks in legal disputes. It is based on game theory, the decision theory, microeconomic concepts, and also aims to explain why parties resolve conflicts out of court and the variables that affect settlement choices. Settlement negotiations are the cost-benefit analysis where the parties can compare the advantages of going for trial against the expenses and dangers of going to the court. With this, we come to the end of today's lecture. Thank you so much for your patient listening.